practices.
Hello, and thank you for joining us for another installment of California Employment News. My name is Meagan Bainbridge, and I'm a shareholder in Weintraub Tobin Labor and Employment Group. And today I'm joined by my colleague, Nikki Mahmoudi, to discuss the importance of having an updated, legally compliant employee handbook. It's a topic that doesn't always get a lot of attention, but becomes quite important when something goes wrong. For California employers, an employee handbook is much more than a welcome document. It's one of the most important tools for setting expectations, communicating workplace policies, and reducing misunderstandings before they become disputes. California has some of the most employee protective workplace laws in the country, which means a well-written handbook can help employers stay organized and compliant while helping employees understand their rights and responsibilities. So over the next few minutes, we're going to walk through what should be included in the California Employee Handbook and why it matters. Nikki, can you start us out with some basics?
Of course. Every handbook should begin by explaining who the company is, its mission, and what employees can expect from the workplace culture. But from a practical standpoint, one of the most important opening provisions is the at-will employment statement. California is generally an at-will employment state. That means either the employer or the employee can end the employment relationship at any time, with or without notice, and with or without cause, subject to applicable laws. A handbook should also make clear that it is not an employment contract and that the company reserves the right to revise policies as laws and business needs evolve. Those foundational provisions help prevent confusion about whether the handbook creates contractual obligations that were never intended. California employers should have a clear policy prohibiting harassment, discrimination, and retaliation. The policies should explain protected characteristics under California law, provide multiple avenues for reporting concerns, and assure employees that complaints will be investigated appropriately. Equally important, employees should understand that retaliation against someone who raises a concern or participates in an investigation will not be tolerated. A handbook cannot create a respectful workplace on its own, but it can establish expectations and communicate how concerns should be addressed. Meagan, what else should be addressed?
The handbook is a great place for employers to lay out their wage and hour policies. California wage and hour laws are detailed and frequently litigated, so a handbook language, it should be clear. Employers should address topics such as work schedules, keeping requirements, meal and rest break policies, overtime procedures, payroll practices, expense reimbursements, those sorts of wage and hour type things. And employees should understand that all hours worked must be accurately recorded and that non-exempt employees should report any missed meal periods, rest breaks, or payroll concerns promptly. A handbook won't replace proper day-to-day management, but it does establish consistent practices throughout the organization. A discussion of leaves and absences is equally important. Indeed, in my experience, one of the largest sections of California employee handbooks is often the leave section. Depending on the employer size and circumstances, the handbook may need to address several different leave rights, including family and medical leave, the California Family Rights Leave Act, pregnancy disability leave, paid sick leave, and then there's a whole variety of other leaves that are outside of those core medical leaves, such as military leave, jury duty leave, bereavement leave, voting leave, crime victim leave, organ and bone marrow donation leave. You know, it's possible that your handbook, if you're a big enough employee, has 15 to 20 different leave policies in it. And so while that's not an exhaustive list, it's important for our employers to understand there are a myriad of leaves and absences that may be available to their employees, depending on their size. And the handbook should explain what benefits might be available, provide a basic overview, and identify who employees should contact for more information. Nikki, what else should employers consider?
So California employers should also include policies addressing disability accommodation, religious accommodation, and lactation accommodation. Employees should know that the company is committed to engaging in an interactive process when accommodation requests arise. Many workplace issues can be addressed successfully when employees understand the process for making requests and employers respond consistently. Every handbook should also clearly communicate workplace expectations. Common policies can include workplace violence prevention, drug and alcohol policies, attendance and punctuality, dress code standards, use of company equipment, and computer and technology usage. Now, depending on the workplace, there may be additional policies that are appropriate. For instance, if you have a hybrid or fully remote employee workforce, the handbook should also address issues such as remote work expectations, timekeeping for remote employees, information security, confidentiality, use of personal devices, communication standards, confidential information, social media guidelines, and then so on and so forth. The purpose here isn't to create an exhaustive list of every possible scenario. Instead, employers should focus on policies that are relevant to their operations and provide employees with reasonable guidance regarding conduct and expectations. Megan, is there anything else employers should know?
Well, perhaps the most important thing, other than having the handbook itself, is that employees should sign an acknowledgement confirming they received the handbook, understand where to find the company policies, and recognize that they are expected to follow these policies. While a signed acknowledgement is not a substitute for compliance, it can be an important record for showing that policies were communicated to employees. Handbooks should also be reviewed and updated annually, usually at the beginning of a new year when the new employment laws have been put in place. What everyone should understand is the best handbooks do more than satisfy legal requirements. They create clarity. They help employees understand expectations. They provide managers with consistency, and they serve as a roadmap for navigating workplace issues before they become bigger problems. And that's all the time we have for today and this episode of California Employment News. You can continue to find our video series and podcasts through the lelawblog.com, the Weintraub Tobin YouTube channel, and wherever you listen to your favorite podcasts. Thank you, everyone, for joining us, and we look forward to reconnecting with you next time. Thanks.